is March 2nd already, and we're getting ready to talk about all sorts of interesting things, including, H-1Bs. It's that season already with registration starting. So let's give people a few minutes to get started. We'll give you some information on best practices for the H-1B season, and we then will talk about some backlogs and other things. I hope you all had a great week. It's a beautiful day outside, a lovely day to take a walk during lunch or something. And like I said, we're just going to give folks a few minutes to join, and then we will get started. I want to welcome all those people who are joining for the first time. And also a big shout out to those people who join us every week for our weekly webinar. And of course, all the folks on YouTube, hello, how are you? So I hope everyone is doing well. So let's get started. Let me see, it is, yes. So let's start off with talking about the H-1B season. And let me see if I can share this. Yes, I can share this. But I'm going to have to move this over here so I can see it. I've got multiple screens up, so you have to excuse me. So it is now H-1B season, and as you all know, filing registration has already started. So what is this? So a few years ago, the USCIS or DHS decided that let's try to find a better way to address H-1B filings, because previously people would have to file and then they would find out whether they got selected or not. Well, that would increase all the legal fees that were associated with the filing, whether a person got selected or not. And then there was this concern, a consideration that not enough U.S. master's degree holders were getting selected. So what did they do? They started this registration requirement. So the petitioners must pay $10 to register for each individual or beneficiary they're trying to register. A petitioner can only register a beneficiary for one position. So if you're registering John Smith, you can only register John Smith as a software engineer. You can't register as the same petitioner, John Smith, as a software engineer and then maybe a software architect. A beneficiary can be registered by multiple companies, and often they will, because you're trying to really hedge your bets. And the basic beneficiary and company information is required. Petitioners can only file complete H-1Bs after they've been selected during the registration period. They say the selection will take place by March 31st. Petitioners and attorneys will be notified electronically if they're selected. And the notice will include a service center filing where they should be selected. And of course, the start date remains October 1st, 2022. Now, last year, the USCIS received 308,613 H-1B registrations, and they initially selected 87,500. But that's not usually what they have done in the past. In the past, they've selected a lot more than what was needed. So last year's selection rate represented a significant decline over what was registered in the past. But what happened was in July of 2021, they concluded a second selection of the registrants and selected 27,717. This resulted in a total of 115,217 registrations. The petition filing period based on that registration selected began on August 2nd and closed on November 3rd. On November 19th of 2021, they conducted a third selection of 16,753 in total. And I think it was day before yesterday, they had announced that they have received enough for last year's quota. So it has become close. This year's, the last year's was 308,613, was a 12% increase over the previous years. And so, it's just yet to be seen how many we will see this year. So let us start with let me see, what do I do? There we go. Some tips for filing your H-1B processes, and I don't know, there it goes, it's coming up, is that, applicants with foreign degrees, remember, you've always got to, if you don't have a U.S. master's degree, if you have a U.S. master's degree, then you don't need a credentials evaluation. But if you don't have a U.S. master's degree, you have to request a foreign degree equivalent. A lot of people they think that, I can't remember how many questions I've had from folks who've said, oh, do I have to be in the United States? No. An H-1B can be filed for someone who's overseas. But most traditionally, a person comes into the U.S. On an H-1B, on an F-1 visa, and then progresses to file an H-1B. So, but if you are filing for someone who does not have a U.S. degree, you'll have to get a foreign degree equivalent. The other thing to look out for is specialty occupation. Remember that H-1B means what? It means that it needs to meet one of the three requirements, that a baccalaureate degree, a bachelor's degree at minimum, that means it's not the maximum, or its equivalent, is normally required for entry into that particular position. That the degree is common in the industry for parallel positions among similar organizations, right? And then that the employer normally requires a degree or equivalent for that position. Or finally, the nature of the specialized duties are such that at minimum, a person would need a bachelor's degree. So that has been a big issue of contention. One of the things that we look for is the Occupational Outlook Handbook, although it's very dated, so that it doesn't really clearly identify that all positions that they've envisioned today. When the Occupational Outlook Handbook came back, user interface was a mouse. So they didn't anticipate smart appliances, all that we could do with our phones. So, you have to take the Occupational Outlook Handbook with a grain of salt. The employer's hiring practices. If the employer has always hired a person with that minimum bachelor's degree for a particular position, then that is prima facie evidence that it is a specialty occupation. Then finally, you look at industry standards. What are other organizations, similar organizations of the same size, what are they requiring for that position? So those are the types of things you look for in assessing whether it's a specialty occupation. Like I said, technology evolved, but the government did not. The secret sauce, though, this is my tip to you, is detailed job duties. Don't use the duties that an employer lists for a job placement. They're usually pretty generic. I always like to use very specific job duties and show how the beneficiary's education is related to executing those duties. And if you do that, and they're more detailed, especially geared towards what the employer is doing, then you're not going to get an RFE for specialty occupation issues. One of the key things is making sure that the USC understands it as if you're explaining it to a 10-year-old. If you make it too complex, they may not understand it. So if you're dealing with an architect that is working on multi-cloud applications, what is that? Why is that so important? It's really important because there's some complexities related with multi-cloud applications. And so, especially as it relates to the database, how it's structured. So those are the types of things you need to explain in your letter of support. The employment. Now, the Biden administration, voided the memo that came out during the Trump administration about contracts and itineraries and contracts and details and so forth. But remember, you still have to show that the employment is anticipated but not speculative. So it's still a good idea to demonstrate the available work. If you have the contracts, a memorandum of understanding. Now, I remember when this requirement first came out, it was hard because more and more people at that time were recruiting folks from overseas. So if somebody's overseas, it's hard for, a company in the United States to issue a statement of work order for someone who's not even going to be entering the United States till October. But I think now most companies realize what the reality of the requirements are, and I have not found that it's been difficult. And so you want to make sure you keep it kind of not only talk about that specific employment, but you also want to talk about the other types of work you have available. Because at any chance, if there's a change in that contract, you can at least relate back to saying, well, I said in case that anything should happen to that contract, we have other types of work where we can place the employee. There is the LCA that's attached to that. And remember, the labor condition application is specific to a location. So you may have to file a new labor condition application, which means you'd have to amend the petition. But those are some considerations between April and October. Now, there is a difference between two types of employment. There is what's called traditional employment versus third-party placement. Traditional employment is when the employee is going to be working at the employer's work site. That's traditional employment. That means you don't have to prove employer-employee relationship because they assume that if the employee is working at your office, that there is a employer-employee relationship. So what do they mean by an employer-employer relationship? Remember, in the regulations, it states that a U.S. employer is the person that can file an H-1B. When you place your employee at a third-party site, the question becomes, who's controlling the employee? So that the USCIS goes by the IRS definition of control of the employee. And there's a list of, I think, 10 to 11 requirements. But some of the things they look for is, and I think this is the most important, how is the employee being supervised? Are there weekly meetings that the employee calls into to the petitioning employer to give progress? Do you have a program management software where everyone has to log in details about the progress of the particular project you're working on site? Who provides the tools to the employee? Does the employer or does the third party, where he or she's being placed? How does the employee ask for any type of leave or vacation? What's that process? If you have a handbook, the handbook is usually pretty indicative of outlining a lot of these things. So I always encourage employers to have an employer handbook for a number of reasons, but it works on the immigration realm as well. And then finally, I'm going to quickly go over cap gap. For F1 students whose employment authorization document pursuant either to their OPT or STEM OPT is still valid. They're not in the grace period, but it's still valid at the time they file their H-1B petition. Even if their EAD expires before October 1st, because remember, October 1st is the effective date of the H-1B, they're allowed to continue working for the employer, with the receipt notice. just showing that they've been selected. If you are on an F1 and you are changing status to an H-1B, you should not leave the United States until your petition is adjudicated. The reason is it would be deemed abandoned. When you are changing status from one non-immigrant category to another, and you depart the United States, they'll still adjudicate the underlying petition, but they will not change your status in the US. You will have to process at a consulate abroad. Once it's been approved, then you can travel. I always, I'm not a big fan of folks traveling on the tail end of their OPT, but I understand that sometimes, there are things that require the travel abroad. So if your H-1B has been approved and you're planning to travel, make sure you take a copy of that. Make sure you take a current letter from your employer saying that you're just going on a short temporary visit and that you will be coming back and you have you're still working, so you have a job offer. These are some things I would do if you're planning to travel as a F1. So let's pivot a little bit right now, and we will take questions at the end. I wanted to talk a little bit about backlogs, the surge of backlogs, right? I mean, the processing delays, as you can see with this chart, at the end of 2013, USCIS had 3 million pending applications. The number increased to 5.7 million by 2019, 6.1 million by 2020, and 8 million in September of 2021, and about 9.5 million as of February 2022. Wow. Now, processing backlogs across the United States have, one second. Processing backlogs across the United States have affected the overall pace of immigration alongside the pandemic-related mobility restrictions. So legal immigration levels are far below normal. Grants of temporary visas dropped by 54% in 2019 to 2020, and then another 30% in 2021. Visas for new legal permanent residents, green card holders, fell from about 48% in 2019 to 2020 and rebounded slightly in 2021, but still far below the pre-pandemic levels. Congress did appropriate $250 million to address the backlogs and support refugee processing at the USCIS for fiscal year 2022, which goes to hiring 200 more staff members at the agency's asylum division. However, vetting, hiring, training for new employees takes a long time, so we won't see the benefits of the funding immediately. But if you have been tuning into our webinars every week, we did demonstrate last week how the numbers for processing I-140s and I-485s have seen some improvement since the year before. So I think in that sense, we have been doing much better. So we will be taking questions. I just request that the folks that have questions place them in the chat instead of paste in the Q&A instead of the chat, so that we will have that. I'm trying to pull up our social media. I know I have it somewhere, so you can register for social media, but please place your questions in the Q&A, and I'll request our moderator to join us, Mr. Challa, if you are.
Good afternoon, Lakshmi and the team and everybody out there, all participants. Welcome to the 2022 H-1B seminar, or I should say 22, but it is for 2023. if, I don't know, I'll leave the legal language to the attorney, but
Yeah,
anyway,
I mean, it's 2022, but for the 2023 quota.
right. So I will wait for people to ask questions while we are, I think there's some discussion on the chat from Daryl. It says it started out, it was evaluated for my master's to be equivalent, but E3 unfortunately does not need WES report, but still useful to have it. So here's a question from YouTube, and there's a question on Q&A, and come at the same time. So the question from the Q&A anonymous attendee, checklist required for initial process to lottery.
Yeah, and I think we went over that. It's very simple, the information that's needed for the lottery, but if you would like a checklist, please feel free to email us at challalaw.com. I don't know if it's readily available, whether Lainey will just share the link.
All right. Question from YouTube. Can the annual salary be composed of base plus bonus?
No.
Devika, maybe? Devika Jung.
Right. So the salary has to be, it's whatever stated on the I-129 has to be issued in no less than monthly increments. So because bonuses are speculative, the salary has to be, it has to be just what is offered in the salary, not the bonus.
All right. This next question is not specifically for H-1B. It's from YouTube, Sweet Seller. After GC approval, how soon should the employer update the pay to the wages offered mentioned in 485J? Very next paycheck after GC?
Yes, because remember, it's prospective employment, so it would be for once the petition is approved.
And a follow-up question from the Sweet Seller. Do you have any updates on the bill which affects EB2 and EB5? You mentioned the bill is slated for March 11th.
Right. I mean, there are talks, probably more serious talks about the EB5 versus the immigration bill, but it's, as I told you, these things are evolving daily, and so we never know until it happens, until the fat lady sings.
Right. All right. Let's see the next question. Don't see any questions yet.
Can't believe there aren't questions.
Employee information. I think the team had put something in the chat. Employee information.
Oh, that's the information that they need to,
The
that's the
H-1B
checklist that they asked for,
registration
yes.
checklist, yeah. So that's what I see. Some new folks for the first time. Balaji Ishwari from North Carolina, welcome. I appreciate Srini to introducing you guys to us.
Thank you for attending. I hope you find this helpful.
Yeah. Daryl, I think you had some question. I wasn't very sure. So if you'd like to ask anything, because in the chat, it started with but I wasn't clear, so I apologize if it's. All right, so there's a question here from YouTube. Let's see what that is. Challenge to get this. Oops. Sweet seller, can renunciation process be done with an expired Indian passport, or should it be active?
Oh, you're not, because you're probably trying to get the OCI, or maybe you're trying to get a visa. I'm not sure of what the Indian requirements are for that. So I would imagine that it would be helpful if you had a valid passport, but like I said, I'm not sure.
I suggest you reach out the nearest US embassy, I mean, the Indian embassy close to you, and ask them, you know. And if it is a drivable distance, I rather suggest you just drive there.
Yeah, if they, I don't know if they're taking in person.
Yeah, but all right, next question from YouTube, Hunter Chop. For interfiling from EB3 to EB2, does the for interfile from EB3 to EB2, does the EB3 I-140 should be approved? Can I where this thing is. That's what it's. Hang on. Let me just close the. Okay. For interfile from EB3 to EB2, does the EB3 I-140 should be approved? Can I interfile as EB2 I-140 is already approved in 2019? My priority date is June 2011.
Yes, and we've got, I think Lainey will share our memo on interfiling, with the new rules, and that should help. Shaker, can you see the QR codes? What am I sharing?
Yeah. Yeah, I can see.
Am?
Yeah.
Okay.
Balaji says they don't, so I'm not sure what's.
You can see it?
Yeah, I can see this QR code here.
Okay, let me try another way. But what I was going to say is, the memo outlines not only the new, I guess, requirements that they have, but also outlines some best practices. So, Lainey, do we have that?
Yes, I'm finding it and posting it right now.
Perfect. There you go.
All right. Balaji says unable to share the link in the chat for H-1B checklist. We'll try to post it again. But Balaji has a question. What is the timeline to submit H-1B initial process?
The timeline to submit, well, it's not really submitting the initial process. It's right now it's registration. So you've got to wait for the registration, and then
excuse me.
And then once you're selected, then you'll be able to move forward. Can you see the QR codes now? Shaker?
I can't see it now.
You can't?
No.
Oh, I don't know what it is. Okay. Anyway, I'll try one more time. But, so, they've already started registration, pre-registration. We started registering people already yesterday. And after pre-registration, then the selection process will take place. And usually by the end of, the end of March, they will let us know. And then once they do that, you have a given time frame where you have to file the petition. And like I said, last year, that they kept selecting. They selected in July, they selected in November. So if you didn't get selected initially, don't lose hope. Can you see the QR codes now?
Yeah.
Okay, great. I just want to take this second for the people who have joined us for the first time. We've got some great, we'd love to connect with you on various social media sites. One of them happens to be our Telegram group, a community of people who are going through similar things that you're going through. So it's always great, right, when you're going through something that's challenging, to have a group of people that you can talk to about it. And we're part of it too, and we chime in when we can. So if you want to join our Telegram group, take your phone, put it up, and make sure you can get the QR code, and then you'll be able to join us immediately. In addition, we're on Facebook. We communicate through various platforms differently. So what you will get on Facebook will probably be very different from, if you join us on Twitter, where it'll be a 2-second soundbite. So same thing again, if you want to join us on Facebook, you can put up the QR code and then you can share it with your friends on Facebook. We would love that. The bigger our community gets, the bigger voice we have. And then these weekly webinars, and as well as, short videos on tips and tricks and strategies for your immigration journey are on our YouTube channel. We've gotten a lot of very, great reviews for people seeing the YouTube channel. So that's something we will continue to put forth content, but you won't know that we put forth content unless you subscribe. So put up your phone, get the QR code, and sign up for our YouTube channel. And like I said, share it with your friends. And then lastly, you are here because, you've heard about our webinars. If you found the information that we've provided helpful and you want to share it with your friends, please do so by pulling up the link and forwarding that off to your friends. And if you want to find a place where you can do it all in one platform, I think Kara created this link where you can link up to all our social media. I should have probably put this first. So you can put your QR code up and connect with us all over the place. And we'd love that. We'd love to hear from you. Any comments, any interests that you have for future webinars, we're happy to, organize that. And I think we'll also have some links in our chat. So in case you're on your phone, you'll be able to use the links in the chat.
All right. Let's go to the next question from YouTube. Shankar Pathare is asking, I'm on E3 visa in USA and would like to move to H-1B. I have recently completed online master's degree in US. Am I eligible for master quota?
Master's quota is for those people who have graduated from an accredited US university. So if it's an accredited US university, yes. Remember, the master's quota, the benefit of that is there's 2 bites of the apple, right? So they select people from, before they were selecting people from the master's, the regular quota, and then, no, the master's quota, and then they were selecting from putting all the master's degree people into the regular quota. I think they've reversed that now, and they have found that there are more master's degree people that are being selected through this process. But if your online course qualifies as an accredited, it's from an accredited US institution, then yes. And remember, if you're planning on getting an H-1B as an E3, because you think that's the only way you can get permanent residence in the United States, you're mistaken. Please take a look at our E3 YouTube video. Through that video, there's so many E3s that are now in the process for filing their permanent residence. because everyone thinks that E3s cannot.
Okay, next question is from Nora. Do employees only get 3 chances for lottery?
There are, pursuant to last year, I mean, years before, what they would do is they would just select more people initially. And the lottery may open up one more time. So it just depends on how many people they select initially and how many of those move forward.
All right. That's about. Don't see any open questions and nothing on the chat yet. So while we are waiting, I just wanted to talk about the EB-5 program. I actually, as the first contact for people who are interested in EB-5, because every EB-5 candidate is typical in terms of what their needs are, the situation, the background, where the money is coming from, and the kids, they have the kids or don't know kids, or kids are just about 20, 19. So a whole bunch of different scenarios are there. So that's why I talk to folks, so if you are interested in the EB-5 route for a green card process, do send us an email, info@challalaw.com. We have a project that I know the project director in Greensboro, North Carolina. There's a Western Hotel and Conference Center. That's the project. I've had 5 investors from India investing in Dubai into that project in the last 3 months. And we were working with 2 others. And somebody asked about the March 11th. So there are some possibilities that things may change. It's all in the talk. We don't know, right? The investment may increase from 500 to 750, but we're not sure. So if you're really interested, it's a good time to, nail down and lock it at 500,000. And we will submit your filing, your I-526. From the time we have all the documents, the money, 5 business days. So just wanted to let you know.
Oh, wow. That's
I've committed on behalf of the attorney and the team 5 business days. That is from the time we have everything, and the attorney.
the completed documents.
The attorney thinks, yes, all the documents are there. There's no gap between, all the supporting documents, because the most important thing is, how did you earn that $500,000? So you have to produce documentation. So, and if Mr. Challa feels like, yes, there is no gap to fill, all the documents look clean, that's what I mean by that. Once that is there, it shouldn't be it's still a task, but we will make it happen. But it's on you to decide. All right. So I just want to, while there's a couple of questions that have come up on the Q&A, another one from an anonymous attendee. Quick question: if I use AOS EAD to switch job from current GC filing employer, then can I continue renewing GC EAD until I get called for 485 interview, or should I join my GC filing employer when called for 485 interview?
No, you can do that. Just remember that your I-140's got to be approved, your 485's got to be pending for 180 days, and it's got to be in the same and similar employment. If that's the case, you can use your EAD to work for your new employer. I always encourage people to have their underlying non-immigrant visa valid. So if I were you, I would try to do that, because you get the 240-day rule when it comes to extensions, whereas you don't have 240-day extension protections for your EAD. You only have 180 days.
All right, next question from another AA. Hi, ma'am, thanks for help. I have a small question. When do you think June 2014 is going to be current in EB3?
Can't predict. As I said before, there's so many factors relating to this. We'll just have to wait and see. We're keeping a close eye on how many, petitions the USCIS is adjudicating. We don't have first quarter reports yet. It depends on that. It depends on what's happening with the State Department and the consulates overseas. All of this, it's like a big formula, and those allocations will impact the visa bulletin movement.
Next question from another AA. My 485 on EB3 got stuck in Texas. Now EB2 has become current. Considering the interfiling, what do you think is going to be the outcome?
Well, when you say you're 45, so your I-140 for the underlying 45 has been approved?
I don't have the answer for that. Maybe the person can, maybe the next one is from the same AA. I got I-140 approved in premium processing, but my priority date is not ported. It is current now. And my attorney, I think that's a different one. So this person answered yes, approved for both.
Okay, yeah. So you've got to, according to the new memo, you've got to wait until you're able to interfile. Please look at our memo with instructions on interfiling. I know the Texas Service Center is like a black hole. It's just, and it has always been that way. I mean, I've been practicing for close to 25 years, and I think there was one period, a couple of years, where Texas wasn't so bad. But for the most part, it's been pretty backlogged historically.
This next question from another AA. I got I-140 approved in premium processing, but my priority date is not ported. It is current now. And my attorney is trying to file I-485. Is that possible, as my new I-140 approval doesn't port my priority date?
Well, if it's recently approved, you can try calling the USCIS to see if you can get a new approval notice with the ported priority date. I don't know if your attorney requested it or not. We always request that in big, bold, and red at the top, just to make sure that it ports. Otherwise, what your attorney would have to do is show the previous I-140 and show that, have an explanation that it's not been ported, but it should have been ported, and then use that in the new filing for the I-485.
The next question is from Raj. I have a question. I have approved EB2 from previous employer. Now my perm is filed in EB3 from new employer. PD is 2013, October. Will I be able to interfile after perm and I-140 approved? What's your recommendation?
Well, you say did you file an I-485 with your previous employer?
Hopefully, Raj, just put your answer in the chat. Maybe you did. Let me see.
The I-485 was approved? You said the I-140 was approved, but if the I-485 is approved, then why are you interfiling or filing another perm right now? The I-45 must not have, yes.
Not 485.
The I-140 was approved.
Yeah, not 485.
Okay, so, what I would do is, you don't need to interfile, since you're going through a new perm process anyway. Once your perm's been certified, if you're filing under EB2, anybody filing under EB2 can file under EB3. So you file with this current employer an EB2 and an EB3 premium processing at the same time. And if you do that, you'll have two approved I-140s that you can use to file your 485.
He says employer is only filing in EB3.
Oh. Yeah, but if you constructed it in such a way, you could have filed for both EB2 and EB3. And it still may be eligible for both. I mean, because the minimum requirement for EB2 is, so there could be a way that it could qualify for both, depending on how many years of experience and so forth they asked for. But you should always do both. You should always try to structure it so you can do an EB2 and an EB3 at the same time.
He says they only go with job required, not my experience.
Oh, okay. So, yeah, well, you can't use a interfiling from your previous employer with your current employer. So whatever you filed the 485, the perm has to be the same. I-140 can be either EB2 or EB3, but the perm has to be the same. This is going to be a different perm. So you can't use your previous employer's I-140 approval for this. You can use a priority date, but you can't use it on the basis of interfiling.
Okay, let's look at the next question from the box AA. Can interfiling be done with an amended EB2, downgraded filed as amendment?
Are you doing amendment because it's a successor in interest?
You can answer yes.
Yes, you can do that. Just remember, though, when you do that, when you file an amendment, you no longer you're amending your previous I-140 to the new EB classification. So as opposed to filing a new one where you maintain the old one and you filed under new classification, when you amend and you do a downgrade, you no longer have the previous classification.
So next one from another AA, just wondering under what circumstances and what percentage does the GC 485 gets denied? I'm planning to use GC80 to switch jobs.
So for the most part, if your I-140 has been approved, unless you've committed a crime of moral turpitude, 2 crimes of moral turpitude, a felony, unless you have a communicable disease that could risk the health of Americans, there's not a big chance that your 45 is going to be denied. Now, on the substantive issue, then there's the other side of, did you file all the required supporting documentation, your birth certificate, marriage certificate, all those other things. Now, they won't outright deny it. They'll usually issue a request for evidence before they deny any application. So it gives you, and in the rare instances, there have been denials where at the 485 stage, they've looked at the underlying perm in I-140 and determined that the I-140 was approved erroneously.
All right, this question is from YouTube, from Fat Loser 420. What a name. Can we travel to India and re-enter USA using advanced parole when EB2 to EB3 downgrade I-140 is pending? Is it okay to do this?
Yes.
And a follow-up question from the same person. I'm currently working with H-1B. Do I have to resubmit I-9 form with EAD information if I re-enter USA using advanced parole? My H-1B is still not expired.
Right. So this is the great thing. You can travel on an H-1B visa. You can travel on your advanced parole. You can work on your H-1B. You can work on your EAD. The only time it's a problem is when you use your EAD to work for an employer other than your H-1B employer. Then your H-1B is no longer valid. But other than that, there's no problem. So you don't need to be re-I-9'd if you enter on a advanced parole. You can continue working on your H-1B.
Raj is asking another question. When you think October 2013 EB3 will be current? It's hard, but any guess?
I can probably give you a better idea after I look at maybe the second quarter numbers. Some idea first quarter, but better idea after second quarter.
This question from YouTube, a sweet seller. Does it impact any of the employment immigration process if extension is requested on tax filing?
No.
And that's all I have for now.
Well, thank you all. Next week, we're going to be going over other types of permanent resident options you may not have been thinking about. And, some interesting non-immigrant categories that you may be eligible for if you are trying to find other ways to expedite your permanent resident status. So what's the pathway? Fast track, green card, non-immigrant options. It's all about speed next week. So join us.
Hang on, one last question. Somebody that I think we asked, but what could be the percent of chance that GCEAD won't get approved in 12 months if it's filed before 6 months of expiry?
What's the chance what?
What is the percent of chance that GCEAD won't get approved in 12 months if it's filed before 6 months of the expiration? I mean, the extension.
Good question. So last week we went over this. The current processing times for EADs is anywhere from 8 to 12 months. So if you file it right at the time you're eligible, which is 6 months prior to its expiration, you get the 180 days, remember, because it's an extension beyond that. So it should be approved by the 12-month time frame.
So there goes Mr. AA or Miss AA, the last question on a good note. Answered.
Yes. So I want to thank my team for putting all this together. I want to thank our great moderator for moderating.
Thank you for the opportunity.
And again, I enjoy connecting with you guys next week. Remember, next week, join us. Please share our, oh, great. I want you to know yes, they are awesome.
Thank you,
and I
Raj.
Share our next week's, because if you all liked Fast and Furious, like the Fast and Furious franchise, join us for the Fast and Furious immigration race.
Telegram group is growing and growing. Somebody said on the Q&A, glad to hear. Please encourage others to join too.
Yes.
Appreciate it.
All right. Thank you guys. You have a great weekend.
Thank you all.